Hudson kwa email gani ile ya yeah. When I don't know why. It has been the former judges are not giving I think they are concentrating on they are waiting because I'm born and I think that that's much village where they are not, and because it is happening, you get that much. Yes.
Kusoma ni njia ya kuelewa. Sasa kwa
anaongeza ulevi. By the hiyo inafungua inachukua. I don't like hiyo kitu kisikizo ya kusema is it part of the affidavit? Is it? Why is it? Just check in the group. That is not for today. He's involved in a matter with us. Don't, and we are not yet yes. I'm good. Whether it looks like a cop, how will it be changed from here? And he's not even a politician. He doesn't even want any change. tusaidiana haitamalizika. Because there are some people who are already aware of what are the issues. Ndio sasa mtume ongeza hizi paragraphs. That is easy way. Unaona anakuja
Good morning once more. We take this opportunity to apologize for delaying you for more than 1 hour. The reason is because when we get here last evening, we had just heard a ruling which needed to be polished and put on 6 years. We have just uploaded it. You can access it. Thank you very much.
Morning, everyone. His Lordship Justice A. Kopala, His Lordship Justice Anthony Mokuma, Her Ladyship Dr. Justice Frida Mugambi, will begin with the bench for today. Petition E570 of 2024, Egi Waiguru and Rita Gachagua versus Senate and National Assembly.
To avoid what we thought would be a lot of wasted time, we have prepared directions which I will be able to read. These directions concern all the files which are before this court. We call them general directions or the consolidated petitions. On 14th of October 2024, this bench was empaneled to deal with the constitutional petitions which had been filed, challenging the process of impeachment of HPL Gachagua. By then, the impugned proceedings were before the National Assembly of the Republic of Kenya. Those petitions were subsequently consolidated by an order of this court, and constitutional petition number P522 of 2024 became the lead file. The impeachment process then moved to the Senate, where His Excellency Gachagua was eventually impeached. Subsequent petitions were filed and conservative orders issued. Those petitions were also consolidated by an order of this court, and constitutional petition number E565 of 2024 became the lead file in the series. Several other petitions that further variously challenged the same impeachment process were later filed, and this bench has accordingly been empaneled to also deal with the said petitions as well. On 23rd of October 2024, all the petitions on which this bench was empaneled to deal with were mentioned before court, and proposals on the way forward by another council and parties were received, especially on the aspect of consolidation. This bench then adjourned the proceedings to today so as to give comprehensive directions in the manner in which all the petitions before this bench will be dealt with going forward. The bench also fixed all applications seeking the requisition of the bench for hearing at 2:30 p.m. today. This bench has gone through all the petitions before the court. We have no doubt that there are principally two sets of petitions. The first regiment are the petitions that challenge the impeachment process before the National Assembly. We shall hereinafter refer to such petitions as those in cohort 1. As said, those are the petitions that were consolidated and constitutional petition number E 522 of 2024 became the lead file. These petitions were fixed for a mention on 29th of October 2024 for the parties to decide on the way forward, depending on the outcome of the proceedings before the Senate. As it is, the Senate proceedings ended in the impeachment of H.P. regarding Gachagua. As a result, several other petitions challenging that process were filed. We shall hereinafter refer to such petitions as those in cohort 2. Those are the petitions that were consolidated and constitutional petition number is 565 of 2024 became the lead file. Having considered the nature of the petitions before us and with a view of conducting those proceedings in an orderly manner, we hereby issue the following further directions. 1. All the petitions shall forthwith be dealt with as those in cohort 1 or cohort 2, respectively. 2. Court shall, pursuant to Rule 17 of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedures, Rules 2013, on its own motion, consolidates any other petition referred to this bench either into any of the two cohorts. 3. For clarity, the petitions are hereby consolidated under the two cohorts as follows. Petition in cohort number 1, Nairobi petition number E 522 of 2024, that's the lead file. Then we have Nairobi petition number E 506 of 2024, Nairobi petition number E 509 of 2024, Nairobi petition number E 525 of 2024, Nairobi petition number E 528 of 2024, Nairobi petition number E 537 of 2024, and Nairobi petition number E 541 of 2024. The petitioners in those consolidated petitions are as follows. 1. Regarding Gachagua. 2. Oguli Namea. 3. Kennedy Kamitiu Gachege. 4. Dennis Okumu. 5. Simon Muchangi. 6. Peter Maina. 7. Jema Watu Association. 8. John Mugo Kiragu. 9. Njomu John. 10. Caroline Wambui Mwangi. 11. Dr. Clarence Egoso Mwaresa. 12. Wanjiru Mwangi. Those are the petitioners in cohort number 1. Respondents in that cohort are 1. The Speaker of the National Assembly of Kenya. 2. The National Assembly of Kenya. 3. The Speaker of the Senate of Kenya. 4. The Senate of Kenya. 5. The Deputy Speaker, National Assembly. 6. Honorable Moses Masika Tangula. 7. Honorable Amason Kingi Jeffa. 8. Honorable Attorney General. The interested parties in that cohort are 1. William Samoei Ruto. 2. Law Society of Kenya. 3. Mount Kenya Jurists. That is cohort number 1. Petition in cohort number 2. Nairobi petition number E 565 of 2024, that is the lead file. Nairobi Petition E 550 of 2024, Nairobi Petition E 570 of 2024, Nairobi Petition E 572 of 2024, Karagoya Petition E 013 of 2024, Karagoya Petition E 014 of 2024, Karagoya Petition number E 015 of 2024. The petitioners in those cohort 2 are as follows. HC regarding Gachagua, number 1, number 2, Thomas Kimoto Maingi, number 3, John Honjen Njeri Maina, 4, on David Nuni Madenge, 5, Peter Gichobi Kamoto, 6, Grace Mdoni Mwangi, 7, Clement Michiri Mweki, 8, Edwin Munene Karaoke, 9, Sharia Mtani na Shadrach Wambui, 10, Father Eddie Waiguru. From them, you know that Father Eddie Waiguru is in the list of E570 of 2024, and they are 32 petitioners. So from Father Eddie Waiguru, we add all the petitioners in that petition, which come to 32 and ends with Gema Wato Association. Respondents in the court are as follows: Speaker, National Assembly of Kenya; 3, Speaker, Senate; 4, Senate of Kenya; 5, on Attorney General; 6, H.E. William Ruto; 7, Clerk of the National Assembly; 8, Deputy Speaker of the National Assembly; 9, on Mwengi Mpure; 10, United Democratic Alliance; 11, Orange Democratic Alliance; 12, Kenya Kwanza Alliance; 13, Ford Kenya Party; 14, Amani National Congress; 15, Register of the Political Parties; 16, Independent Electoral Boundaries Commission. In that cohort, the interested parties are follows: the Law Society of Kenya, Professor PROF Kindiki, Wiper Democratic Party, Jubilee Party of Kenya, Katiba Institute, Mount Kenya Jurist Association. And then left the Kituo the Sharia. Pursuant to those, we direct that all filings and service of documents shall be done electronically through the court's electronic portal in the respective court's lead files. Parties shall accordingly ensure that they are duly marked into the system. The Honorable Registrar of this Commission shall assist if need be. Any counsel or party appearing in these petitions shall, before the start of any court proceedings, record such appearance in the quorum forms that shall be provided by the court assistants in this bench. Those appearing virtually shall as well log in and register their presence through the court assistants. As directed on 23rd of October 2023, any application in either of the cohorts seeking the recusal of the judges in this bench shall be heard today at 2:30 p.m. Those directions can be accessed in this court's electronic platform. Then these directions can be accessed in this court's electronic platform in the respective lead files. This court shall give further appropriate directions in the respective cohorts lead files as and when necessary. Thank you very much.
You're actually say, well, we can get that part of the ruling.
The directions,
Yeah.
subject to amendment which have come from you, will amend it and then upload it.
Thank you, sir.
Madam Design Commission, we are guided by the directions issued by the court. We however have one concern from our side, my lords, Lord, there are interim orders that were issued in Kerugoya, and in our understanding, from our interpretation, once the file was referred to this court, the orders expired today. That's our understanding. My Lord, we are going to seek the court's guidance on the hearing of our application dated 18th October. Of course, we understand that there is a recusal application today. But given the fact, my Lord, that our interpretation is that those orders would expire on the appointed date, which is today, when the matter was meant to be mentioned, our colleagues' understanding, my Lord, that the application, in the public interest, be prioritized so that we are able to hear the application for setting aside of those orders. In any event, my Lord, the orders in question were issued by one judge, the matter has now been referred to a three-judge bench. And their nature is problematic, as mentioned by the court. And we pray that in terms of aligning the hearing, scheduling the applications to be had in court, that if possible, my lords, we do not want to do anything outside the law. We would request the Lord that we do that today, if it's possible, because the orders expire today. I think we have tried to go. We just want to have something on that.
My Lord, very briefly, I only want to repeat what my Lord, I just like to indicate that I would not want to repeat what Senior Counsel Professor Promogenda has indicated, but just for completeness of record, there are two applications. There's one by the Honorable Attorney General and one by the National Assembly dated the 18th of October 2024. We are ready to do that for them as soon as they're ready.
My Lord, with your kind permission, Daniel Manson, appearing for the Law Society of Kenya and also for White Party Democratic Party or interested parties. My Lord, if the orders are to expire today, then that will be at midnight. My Lord, the day is not yet over. We have applications in the afternoon. We are also affected by those orders. And my Lord, I suggest after the applications today, then we can discuss that matter before the court adjourns. And thank you, my Lord.
My Lord, Kibe Mungai, on behalf of the petitioners, there are two issues. You can see the senior, the team leader, Honorable Paul, which is not last in the council. That is the first thing that we will deal with it in the afternoon. And as far as we are concerned, the matter is premature at the hearing and determination of that applications for the simple reason that the issue and an order has already been made that will be first dealt with by the court after its ruling on yesterday was the application for recusal. The other matters that relates to how we shall deal with the petition, and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, if it continues, the issue, my Lord, of a back and forth on what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have sat a little bit late, there is some work we still have to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, Paul Mute is in the afternoon, it will be brought in the afternoon. But my Lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my Lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the Mutula rules, the rules of procedure that are applicable. My Lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday and the ones that were filed even on Friday last week are maturing their last dates for responses. My Lord, as we sit here, we are yet to receive any substantive responses to those petitions in either forms from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the Mutunga rules to the full. Now, the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last position, so that they are not termed as academic. So that, my Lord, towards that, the petitioners, including the petitions where I'm participating, we had requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents will indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses, because, my Lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because, as you have said, these are interim directions. And number 3, in order to be able to determine issues for determination, and these are issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties, that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, we complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we are ready in the afternoon. We are more soon.
I think my because I'm on the spirit of house, so you can have some response on it. In your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of counsel for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kiruga, your Lordship, was categorical that he granted prayer number C, even as we await senior counsel Paul Mwete to come in the afternoon. The wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and determination, of this application inter parties, this honorable court be pleased to grant the order that were granted. That is therefore to me, your Lordship, that question that senior counsel was raising has no sitting in the pleadings before you. Number 2, your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I've had the advocate for the respondents insisting on the urgency to hear the application for setting aside, your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file the replies. Your Lordship, I hope you're following. It doesn't seem to be foreign. Why do you say that? Why do you say that? But you leave it, let me leave it at that.
Thank you. I think that is.
About on a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua, the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for filing of responses, because we speak now, we have not received those responses from the respondents. Then number two, my colleague Senior Kibe has raised issues on filing of responses, so that in 522 we have given an indication that we might require to amend our pleadings, so that before the ruling that was delivered by this bench, there was indication that we might require to amend the pleading. That is in petitions in cohort number 1, so that if the court can grant us leave within 3 days, those amendments can be done, and thereafter this can also probably affect some petitions cohort number 2. So it is important that we get that particular direction. Finally, my lords, this proceeding, because of the nature, the way they are proceeding, would request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding at any time, those can be available for purposes of good order. That is all.
May I say something?
With due respect to council, we do not intend to make today this hearing a long hearing. We have been practiced enough, we have read our directions, and I think you should let us wait for proceedings in the afternoon.
I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend their petitions. How would petitions that are to be amended be responded to when actually it should be amendments that should come first and then responses follow? Two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, but it is actually aggrieving the respondents and should be set aside, the Kilowaya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the expected conservative orders. Therefore, that agency cannot be lost or cannot be clouded with whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
I apologize. We are raising so many issues. I do apologize. And we have to be patient. When I made an application for people to select to enjoy my Lord Justice Kampala, you are very kind. Now, you probably allowed my application because the failure was to be done, and also I was to be done by the museum. You have not mentioned if you would be kind enough.
In which petition?
Yeah.
In which one? Which cohort?
This, I'm going to do that paper, but this one.
In your own name?
Yes, in my own name. John M. And of course, it was in John.
So you are petitioner number 8?
No.
Interested party number 8?
That's all. Thank you very much.
Thank you, my lord. We just want to restate the position that the agency in this matter cannot be gainsaid or cannot be lost alone. Under the contention that the replies have not been made, that we have not made the replies, is not correct. because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empanelment of these judges will actually be lost, because then we will be going back and forth, and at the end of the day, my Lord, we will not have served the public, the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my Lord. We would ask that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for God to direct parties when to respond to pleadings. It is not for God to direct parties when to respond to pleadings. But one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. No party will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles. We need to do that.
Tunasonga mbele watu wote wa Jamhuri Kenya yetu. Tunasonga mbele watu wote wa Jamhuri Kenya yetu. Haya sisi sote wananchi tushangilie. Eko Jamhuri, eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Eko Jamhuri, eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Mwaka wa 60 umefika, tangu Kenya iwe huru. Mwaka wa 60 umefika, tangu Kenya iwe huru. Haya sisi sote wananchi tushangilie. Eko Jamhuri, eko Jamhuri, sote eko Jamhuri Kenya yetu yaenda mbele. Eko Jamhuri, sote eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Kweli twaenda mbio, Kenya yaenda mbele. Waelimika kweli yavutia, tunajivunia Kenya nchi yetu, kweli yapendeza, kweli yavutia. Kenya nchi yangu nitaitoloza, nitailinda maishani mwangu. Kenya nchi yangu nitaitoloza, nitailinda maishani mwangu. Ziwa la Victoria linaunganisha Kenya na Uganda, Kenya na Tanzania. Fika Mombasa, mito wa bahari, ogelea maji, jua tamu kuota. Kenya nchi yangu nitaitoloza, nitailinda maishani mwangu. Kenya nchi yangu nitaitoloza, nitailinda maishani.
Services of this hospital. Lord, we commit to you every equipment that is in this place, that it will fit together and work for the glory of your name, and in a way that will support the healing of many that will come through here. We dedicate all the doctors, we dedicate all the nurses and all the staff that will be working in this place. May their hands from now and henceforth be hands of compassion and healing. Be tender hands that will receive many thousands, if not millions, that will come through here from all corners of the world. As your children, we dedicate this building to you, that this place will remain to honor your name. We dedicate the chaplaincy services, that we see right here the chapel, standing from the ground to the top, signifying the significance of the gospel and the light of Jesus Christ for the world. And as your servants, God, we pray that Tenwek Hospital will remain. We treat, and the ultimate healing will come from Jesus Christ. And so as your children, we dedicate this structure to you in the name of God, the Father, the Son, and the Holy Spirit. And God's people say, amen and amen.
Now invite His Excellency to cut the ribbon to officially open the AGC Tenwek Hospital Cardiothoracic Center. Welcome, Your Excellency. At the count of 3, 2, 1, let us appreciate His Excellency with a round of applause. And now His Excellency will be taken to a guided tour. Welcome, sir.
and a cardiac arrest. He is the face of the future of Africa for cardiac arrest. So the whole hospital is built on this 4-bed pod concept. So this is all critical care for because again, that first 24 hours is absolutely critical, and people are here 24/7, every minute taking care of this. We will start. Four-level chapel with a brand new. I'm a musician. They just put a brand new Yamaha grand piano in. That's where I'll be spending my time.
That chapel is named in honor of his father, who was a missionary in the home, and had several massive because of that it influenced the son to be a medical. Wow.
It was the one thing I asked, to name the chapel after my father. And it has a look like this, which can be variably interpreted as like a flame. So we are a city set on a hill, the light that or as praying hands. And again, it's really very much the centerpiece of the whole facility. Patients would come in before surgery here. There's a family waiting area. Where we have counsel with some of them and their families, tell them what to expect. Then they would exit this way. This is the chapel on the top floor here. And I believe we may take a walk through there. And so we finish our tour.
Let's go faster.
Well, there's like 13 doors. So once you finish ICU, we get patients out of bed the morning after surgery. They're out of bed. And then within a day or two, or in we run what we call a residency program. So one
Tunasonga mbele watu wote wa Jamhuri Kenya yetu. Tunasonga mbele watu wote wa Jamhuri Kenya yetu. Haya sisi sote wananchi tushangilie. Eko Jamhuri, eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Eko Jamhuri, eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Mwaka wa 60 umefika, tangu Kenya iwe huru. Mwaka wa 60 umefika, tangu Kenya iwe huru. Haya sisi sote wananchi tushangilie. Eko Jamhuri, eko Jamhuri, sote eko Jamhuri Kenya yetu yaenda mbele. Eko Jamhuri, sote eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Kweli twaenda mbio, Kenya yaenda mbele. Kwa elimu twaenda mbele, matibabuni twaenda mbele, viwandani twaenda mbele, na mashambani twaenda mbele. Eko Jamhuri, sote eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Eko Jamhuri, eko Jamhuri, eko Jamhuri Kenya yetu yaenda mbele. Tunajivunia Kenya nchi yetu, kweli yapendeza, kweli yavutia. Tunajivunia Kenya nchi yetu, kweli yapendeza, kweli yavutia. Kenya nchi yangu nitaitoloza, nitailinda maishani mwangu. Kenya nchi yangu nitaitoloza, nitailinda maishani mwangu. Ziwa la Victoria linaunganisha Kenya na Uganda, Kenya na Tanzania. Fika Mombasa, mito wa bahari, ogelea maji, jua tamu kuota. Kenya nchi yangu nitaitoloza, nitailinda maishani mwangu. Kenya nchi yangu nitaitoloza, nitailinda maishani mwangu.
PPMC Production.
Tushangilie Kenya, taifa letu tukufu, Kenya tunayoipenda. Kenya nchi tunayoipenda. Kenya nchi tunayoipenda. Twajivunia sana tukijiita wa Kenya, nchi yenye baraka. Kenya nchi yenye baraka. Kenya nchi yenye baraka. Kenya makao yetu ni nchi ya kupendeza, kamwe hatutaiacha. Kamwe Kenya hatutaiacha. Kamwe Kenya hatutaiacha. Mwenzangu, Kenya kipenzi chetu, hatutaiacha milele daima. Kenya kipenzi chetu.
Kaishan will produce Kenya's first kilogram of the green fertilizer in 24 months from notice to proceed. Your Excellency, we know it's not easy to achieve this target, and we definitely need your Excellency and your team's full support. Thank you, thank you, thank you. With your unwavering commitment and support, both our teams together will accomplish this great project and create a new landmark of the green industrialization in Africa. We will closely work together with the Kenya government, our partners in the country, and the local communities. And in this project, and also in all the future projects. Through all these projects, we are not only to pursue the green and renewable energies, such as the green electricity and the green hydrogen and the green ammonia, but also to create more jobs and to result in more economic impact on local communities. 30 years ago, when I was working on my PhD in United Kingdom, one of my housemates was from Kenya. It was the first time for me to have an opportunity to know the better Kenya, its great people, and the beautiful country. Since 2017, I have traveled to Kenya many times, and I have witnessed the huge changes and achievement in the country. I'm so glad and honored that I can contribute to the very small part of the achievements. And Kenya is so proud and honored that it can contribute too. Of course, we will do more and better, and we must do more and better. In about 10 days, I will go back home to United States to vote our next president. I wish, hopefully, we will have a new president who will have the same vision and commitment as Your Excellency on the green and the renewable energies and on the sustainable development. Thank you very much.
Thank you, Dr. Yan. With your permission, Your Excellency, allow me now to invite Her Excellency Governor Nakuru, Susan Kihika, to come, make a brief remark, recognize other leaders present, and thereafter to invite the Cabinet Secretary. Welcome, Governor.
Thank you. Your Excellency, Honorable Dr. William Samoei Ruto, the President of the Republic of Kenya and Commander-in-Chief of the Kenya Defense Forces, Honorable Opiyo Wandayi, the Cabinet Secretary for Energy and Petroleum. I have also seen Honorable Chirchir, I think he's, okay. Honorable Alex Kamau, the Principal Secretary, State Department of Energy. Honorable Walter Nyambati, the Chairman, GDC. Mr. Paul Ngoge, the CEO or Managing Director, Geothermal Development Company, the Board of Directors and the staff. Dr. Yang Tan, the General Manager, Kaishan Group Limited. Members of Parliament present, members of the County Assembly of Nakuru present, county government officials, distinguished guests, ladies and gentlemen. Let me begin by first introducing the honorable leaders that are with us here this morning. And I will start with Honorable Gikaria, the MP, Nakuru Town East. Thank you. Honorable Arama, the MP, Nakuru Town West. Honorable Lisa Chelule, our County Member of Parliament. Honorable Irene, the Honorable Member of Bahati Constituency. Honorable Kamket, I think our nearby neighbor, Mheshimiwa from Tiati. We have the Honorable Senator Wakoli from Bugoma. And we have Mheshimiwa Tom Ondege, who is the MP Nyatike. We had the Honorable Senator Aaron, who is the Majority Leader and Senator of Kericho, with us. And we have our area member of the County Assembly, Mheshimiwa Rutok. Thank you. Your Excellency, it's my distinct pleasure and honor to join you this morning as we break ground, the ground for the construction of a 35 megawatt power plant by the GDC here at the Menengai geothermal project in Menengai, Nakuru County. I take this earliest opportunity, Your Excellency, to welcome you and everybody else here to Nakuru County and especially here in Menengai, Rongai sub-county. My sincere appreciation to the GDC company and All Power 22 Limited for making it possible for us to congregate here to launch the construction of our of a power plant that will add 35 megawatts to our power generation. We applaud you, Your Excellency, and encourage you to continue cementing Nakuru County's reputation as the home of geothermal energy. Your Excellency, today's groundbreaking ceremony for the second 35 megawatt power plant in Menengai is a great milestone towards the utilization of the initial 105 megawatts of steam here in Menengai, Nakuru County. And in so doing, positioning the county of unlimited opportunities as the home 22 adds into our power mix a considerable fraction towards our national commitment to green energy. We eagerly await, Your Excellency, the acceleration to finalize the utilization of the remaining gathered steam. We are confident that the attraction of independent power producers, the IPPs, such as Kaishan Energy and Sosian Energy, among others, is a clear vindication that Nakuru County has in place an enabling environment for local and international investments in energy generation and other sectors. I'm glad to report that in addition to an enabling environment for investment, we have developed business-friendly policies, among them the single business permit and prompt land application approvals and attendant regulations in an effort to attract more investors in manufacturing and industry. Whereas we recognize and celebrate today's groundbreaking of the construction of the power plant, which is a great milestone towards the government's commitment to increase generation of power to the 5,000 megawatt target, we are also cognizant of the more opportunities that can be derived from steam and bring use beyond the national grid. To this end, the county government of Nakuru, in partnership with GDC, is keen in developing a framework for local and international industrial developers' engagement for the utilization of available resources, and in particular, the county government of Nakuru is desirous to accelerate green industrial development within the county. It recognizes its rich endowment of arable land for production of food, animals, and forestry products, and has abundant renewable energy resources, including geothermal, wind, and solar, and recognizes the urgent need to prioritize creation of new and sustainable industry-based jobs to leverage on available resources like geothermal energy and untapped potential in agriculture and agribusiness, among other opportunities. And significant land attendant utilities and infrastructure is now available for immediate access and development in Nakuru County. It is our belief and vision, Your Excellency, that through such a framework, we will attract more investors, restore and grow our manufacturing sector by leveraging on available resources like geothermal energy and the untapped potential in agriculture and agribusiness, among other opportunities. Your Excellency, Nakuru County, in collaboration with GDC, has set up the Green Industrialization Task Force, the GIT, to spearhead accelerated development of green industries, which will take advantage of the green energy and other resources and infrastructure, our vibrant agricultural production sector, and highly skilled manpower, with a view to supply the cities of Nakuru, Nairobi, and Mombasa, and other major towns and rural areas across the country, and supply export markets in the common market for Eastern and Southern Africa, COMESA region and beyond. So, Your Excellency, I won't say too much more. I have a lot more to say about this great county of Nakuru, but I also realize time may not be on our end. So to achieve our commitments, the government of Nakuru County has requested for technical assistance from Power Africa, USAID, who have finalized a feasibility study to support our ambitious urban solarization program in all of our major towns in Nakuru. With your support, Your Excellency, Nakuru can become the best model city on the utilization of direct use of geothermal energy in Africa. We therefore kindly request full feasibility study on this and your government support on public-private partnership investors to utilize this available steam and brine. I will endeavor in exploring bringing on board more partners to fully support making Nakuru a full green county. In conclusion, Your Excellency, we feel proud to be associated with GDC and All Power 22 for this great milestone, not just here in Menengai, but countrywide. We will continue to provide a conducive investment regime for all investors to flourish as we seek to develop Nakuru County. We pledge to work closely with the national government, state corporations, private investors, and individuals on our journey to restore Nakuru as the hub for industrial and agri-business. Asante, Your Excellency. It is now my honor to bring on board or call the Cabinet Secretary, Ministry of Energy and Petroleum, the Honorable Opio Wandai, to come and speak and invite His Excellency, the President. Asante, Waziri.
Your Excellency, Dr. William Ruto, President of the Republic of Kenya and Commander-in-Chief of the Kenya Defense Forces, Governor Susan Kihika of Nakuru County, Principal Secretary for Energy, we stand before you today at this very, very important juncture in the history of the energy sector in the country. Your Excellency, today's event marks a major milestone in the development of our energy infrastructure in the country. Your Excellency, as a ministry, I must appreciate that you have really given us very easy work. Your Excellency, our work as a ministry is simply to implement your policies. And your policies, Your Excellency, flow from your very progressive agenda for the country. And therefore, our being here today is part of that process of implementing your policy direction, Your Excellency. Your Excellency, this particular power plant, whose groundbreaking you have officiated today, this particular power plant by All Power 2022, All Power 22, is going to not only add additional power to the national grid, but is going to go a long way indeed, in terms of creating an opportunity for investors to come into our country. Your Excellency, investors invariably follow energy. And not just energy, but affordable and reliable energy. And that is what this power plant is going to achieve. And especially energy from geothermal resource, Your Excellency. Your Excellency, when investors come, ordinarily, of course, we shall have more opportunities for employment of our young people. Secondly, Your Excellency, what this power plant is going to achieve is to enable us to meet our commitment under the Paris Agreement, of 2015 on climate change, Your Excellency. By enhancing our installed capacity from green energy, Your Excellency, we shall be, of course, working towards achieving our commitment towards global warming mitigation, Your Excellency. Thirdly, Your Excellency, today we are not only witnessing the groundbreaking for this power plant, we are also going to witness the signing of an agreement, of an MOU between Kaishan Group and Kengen, Your Excellency. That agreement is going to make it possible for the first time for this country to develop green hydrogen and then ammonia and eventually get fertilizer for our agriculture, Your Excellency. And that will contribute immensely towards the realization of your objective of food security, Your Excellency. And finally, Your Excellency, let me say this, that as a ministry, we are committed to continue to enhance our national grid. And that is a commitment we are very proud that you have your support. We are working closely with other institutions, including Parliament, to create an enabling environment for us to continue to generate more power from more power producers, Your Excellency. Finally, before I conclude, Your Excellency, I cannot fail to recognize the immense contribution and support that we have received from the political leadership of Nakuru County, led by High Excellency Governor Susan Kihika and Waheshimiwa Wabunge. We continue to rely on you for your support, which is invaluable for us to be able to undertake our projects. Let me also acknowledge the support we have been able to receive over time from development partners, especially AFDB, AFD, JICA, EIB, and World Bank. I also want to acknowledge the support we have gotten from the KFS, the Kenya Forest Services, who gave us this land. Okay. Last but not least, I want to acknowledge the support from the National Treasury, which is ably represented here by Lawrence Kibet. Thank you very much for coming through for us. The AG's office and all the leaders from our sister entities. I can see there is EPRA here, there's KenGen, there's KPLC, and there's KTRAC. So without further ado, Your Excellency, it is my pleasure and great honor to invite you to come and address your people. Karibu sana Mheshimiwa Rais. Tusimame tumkaribishe Mheshimiwa Rais. Karibu sana.
Asanteni sana, tafadhali tunaweza kuketi chini. Thank you very much. Mheshimiwa Waziri, Mheshimiwa Gavana, Katibu wa mambo ya kawi, waheshimiwa maseneta na wabunge, viongozi wote, ndugu watu wa Nakuru, hamjambo. Nakuru hoye. Mimi kwanza nataka nimshukuru Mungu kwa kutupatia nafasi hii. Tumefika hapa Nakuru County kwa mara nyingine tena. Niwashukuru viongozi na wananchi wa Nakuru kwa ushirikiano wenu na serikali yetu katika mambo ya maendeleo katika sehemu hii ambayo yanahusu Nakuru County na nchi yetu ya Kenya. And this morning, I am delighted to be with you at this highly significant milestone event here in Menengai, Nakuru County. Our nation is taking a big step forward in our quest to achieve the historic goal of a national electricity power grid that is 100% green by 2030. Aside from this important objective, the commencement of this project to establish a 35-megawatt power plant by Or Power 22 highlights our commitment to unlock Kenya's vast geothermal potential to drive economic growth. It is also a clear demonstration of our strength in mobilizing private sector investment to develop critical infrastructure and provide essential services, thereby accelerating economic transformation. So far, we have tapped only 950 megawatts, a small fraction of our geothermal potential of nearly 10,000 megawatts, leaving immense opportunities still untapped. And I want to encourage other investors alongside Kaishan, Or Power 22, Globalec, Socian, and all the others, that there is still immense opportunity in the geothermal resources of Kenya. We've just touched less than 10%. So we have a whole 90% to go. And the government of Kenya is ready and willing and prepared to work with the private sector to unlock this potential. We call on the private sector to take full advantage of this and move more decisively and with the necessary speed. Although we are yet to utilize our full geothermal energy potential, Kenya is the 6th largest geothermal producer in the world. More impressively, geothermal energy accounts for over 50% of our national power mix, making our nation a global leader in this sector. The completion of the 105 megawatt Menengai project will elevate Kenya's global ranking to 5th overall globally, establishing beyond all contestation that economic growth and clean energy development can go hand in hand. There has been a proposition that clean energy cannot sufficiently drive economic growth because of its cost, but we are slowly demonstrating that it is possible to be clean and it is possible to develop. For a long time, the fact that geothermal energy is green, resilient, and sustainable has been the basis of our national strategy to expand our investments aimed at decarbonizing the national grid and driving our progress towards net zero. As a global leader in this space, Kenya continues to demonstrate how every action and every nation can achieve sustained, rapid, and transformative growth while remaining true to their climate action commitments. Our achievements today are hardly by chance or miracle. Rather, they are the result of consistent work and investment guided by a vision of national development committed to achieving prosperity while remaining mindful of the Earth's ecological sustainability. Only a few years ago, after independence, Kenya boldly embarked on this necessary path to transformation by investing in renewable energy long before it became a global priority. Today, 73% of our installed capacity is from our renewable resources, contributing over 90% of the electricity distributed nationally. The Ore Power 22 plant is the third facility within the Menengai 105 megawatt complex. Not far away, just here, we are continuing to expand our geothermal operations in Olkaria, Eburu, and Baringo, where over 75 megawatts have already been proven and will soon be added to the grid. Kenya's Rift Valley is establishing itself as a repository of abundant clean energy resources, a fact that should motivate our industrial and commercial sectors to invest confidently in the significant expansion of domestic manufacturing capacity. And I say this because we did commit ourselves that Nakuru is not only going to be the place where we are generating green energy from geothermal resources, but it is also going to be the industrial county of Kenya. As I committed to the people of Nakuru that we are going to expand the facilities in our industrial city in Naivasha, we have just concluded the purchase by government of an extra 5,000 acres of land that will form the industrial complex here in Naivasha. We have moved a step forward as I have this conversation with you. Next week, there will be a major conversation on the project that was launched when I visited the United States between Microsoft, G42 of UAE, and Kenya that will, for the first time, establish data centers in Naivasha powered by geothermal, and that will cost close to $1 billion of investment here in Nakuru County. This power generation speaks to our industrial capacity, our investment potential, and Nakuru County is going to be the epicenter of these activities. Let me commend that affordable, reliable, and clean energy is fundamental to economic transformation, and every new megawatt brings us closer to eradicating energy poverty while boosting productivity and competitiveness. Our geothermal reserves are a national treasure that must be harnessed efficiently to support inclusive growth. And as we concentrate on generating this energy out of Nakuru County, we are mindful that the people of Nakuru County must benefit from this energy. And it is the reason Waziri and his peers have committed resources that will make it possible for Nakuru County. 2 billion shillings have been allocated this year for the last mile connectivity of another 15,000 people in Nakuru County to access power in their homes. We are here to confirm the government's commitment to enhance economic efficiency and industrial competitiveness by lowering electricity costs. Additionally, our strategy to provide universal access to clean, affordable, and reliable energy is clearly on course, and geothermal power remains central to these grand efforts. Given the continually rising fossil fuels and the intensifying threat of climate change, investing in renewable energy is efficient, prudent, and sustainable. This is precisely what we are doing with geothermal energy. Upon completion, this plant will generate affordable power at Kenya shillings 8 cents per kilowatt hour, significantly lower than the cost of fuel alternatives, including fossil fuel. Investors like Or Power 22 exemplify the value of government-private sector collaboration in attracting foreign direct investment and creating employment opportunities for our young people. And it is important for me and instructive for me to say that the investment we've come to launch here today is not funded by the government of Kenya. This is an investment by the private sector. They are going to put their money, 12 billion shillings, into this project, generate energy, and we will buy the energy from them. It is the exemplification of private-public partnership. To unlock the resource we have here, we need the private sector to invest. And with their investment, we get the energy. With their investment, we create jobs. With their investment, we expand industrialization. And therefore, there is a win-win outcome when the private sector and the public sector work together. Many people would have expected us as government to borrow money and come and invest in this facility. That is not the right way to go about it, because we do not want to burden the people of Kenya with either additional taxes or additional loans, when the private sector can do it much more efficiently. And that is the reason why Socian is a private investment. We are now getting power from there. Globlec is underway, and we are now starting Kaishan here. Through the instrument of power purchase agreement, we create the nexus between public resources, private investment, to unlock the potential for us to get our growth underway. It is also the same principle that we have used in developing the expressway in Nairobi. Private investors invested in the expressway. We are using that facility. Through tolling, they are collecting their investment. It is also the same principle that we are using on our transmission lines. I am very happy that for the first time in Kenya today, we will have a transmission line from here in Menengai that will go to Olkalau, that will go to Nanyuki, supply power to that region all the way to Meru. They will, for the first time, access geothermal power from Menengai. That investment is being made by the private sector. The Adani Group are investing in the transmission line, their money, 95 billion. We would have otherwise gone to borrow that money, burden the people of Kenya. This is now a private sector investment, the same way Kaishan here is a private sector investment, the same way Socian is a private sector investment. We will pay for that transmission line using a willing charge that has been negotiated. And it is important for us as a nation to appreciate that a partnership between public and the private sector gives us a win-win outcome where we can deliver public services and public goods using the efficiency of the private sector, investment of the private sector as a way of supporting overall development in our country. I urge the Geothermal Development Corporation to develop and sustain a high capacity to offer effective leadership in driving Kenya's energy transition. Although geothermal power and geothermal projects are complex, the GDC must remain capable of facilitating swift progress with respect to Menengai and other projects by utilizing local labor as well as technical skills and expertise to promote self-reliance and national pride. Additionally, the GDC must intensify innovative exploration, such as the use of geothermal heat for industrial processes and greenhouse farming. The development of the proposed integrated industrial park here in Menengai. I am listening to Governor here that you are working around the clock to make sure that we have a conducive environment that will make significant contribution. That Menengai Industrial Park, which I am looking forward to working with the county government to unlock its potential so that we can use this energy to promote more investment, more industrial investment, so that we can create more jobs and export more products from this county. And it will make a significant contribution to the sustainability and global competitiveness of Kenyan manufacturing and Nakuru County and our country as well. I take this opportunity to congratulate All Power 22 on the progress of your important investment and to express the appreciation for your strong vote of confidence in Kenya's economy. It takes a lot of confidence. It takes a lot of belief. You know, sometimes it is strange that investors believe in Kenya more than we do as Kenyans. This Cation, a company from America, has built confidence in our country. They are putting their money, 12 billion shillings in this project, because they believe in Kenya. I want to ask us as the people of Kenya to believe in ourselves and believe in our country. As a valued partner in our economic transformation, the government is committed to facilitate All Power's efforts to ensure that your investment succeeds in supporting our national development. And as you requested, you have my support, the support of the government of Kenya, as you look at other opportunities, because as I have said, we have just scratched. We have an additional 9,000 megawatts that is untapped. We are working with GDC to make sure that we unlock this potential. We are in the process of having a conversation with Afrexim Bank. I have informed the governor of Nakuru so that we can build the infrastructure on the 5,000 acres we have acquired so that we can begin to interest more manufacturing capabilities into Nakuru County, into Naivasha Industrial Park, so that we can create more value, we can create more products, we can hire more young people, and we can make our country and county much more competitive. I am very proud of this moment that we are making steps as a country in the right direction. We are dealing with the challenge of climate change, and I am very excited that today we will be signing the agreement that will produce in 24 months, that will produce the first hydrogen, the first ammonia, and the first fertilizer for our farmers from geothermal power here in Kenya. I am very happy that Cation has announced that they want to make it a reality, that in 24 months, did you say 24 months? 24 months, we will produce the first grain of ammonia fertilizer for our farmers here in Kenya. And progressively, we will reduce imports of fertilizer into Kenya. And progressively, we will use hydrogen for our fuel. We don't have to import diesel and all the others progressively. And progressively, we will also be turning, and I'm happy that the Minister for Roads is also in our midst, that we will be looking at reducing the number of vehicles that use fossil fuel, and we will be using more of our generated energy from geothermal and other renewable resources to power our transport sector, our cars, e-mobility, and all the other interventions that we are working on. So kwa watu wa Nakuru, nataka niseme asante sana kwa kutukaribisha hapa leo. Nataka niwahakikishie yale mambo yote tumepangana pamoja na nyinyi, tutayasukuma isonge mbele. Hii program ambayo ni uhusiano kati ya private sector na serikali ni ya muhimu. Najua bado mnangojea kwamba kutoka hapa kwenda Nairobi bado ni shida kubwa sana kwa sababu ya barabara imejaa msongamano wa magari, kwa sababu magari imezidi. Mimi nataka niwahakikishie ile kampuni ya Ufaransa ambayo ilikuwa imepatiwa kandarasi ama ilikuwa imetoa PIP yake kutengeneza hiyo barabara, wamekwama, na sasa tumewaambia waondoke ili tuweze kutafuta kampuni nyingine, kwa sababu barabara kati ya Nakuru hapa Mau Summit na Nairobi lazima tuifanye iwe dual carriageway, ndio watu wa Nakuru na watu wa Western Kenya waweze kwenda nyumbani bila ya matatizo ya jam ambayo sasa tunaona imezidi katika hiyo barabara. Mimi nitashirikiana na viongozi wenu katika kutatua jambo hilo, tuweze kutafuta kampuni mpya ambayo itatusaidia kupeleka kazi yetu ya maendeleo mbele. Kwa hivyo asanteni sana, nimeshukuru sana kufika hapa siku ya leo, na mimi nataka niwaulize sote tuweze kushirikiana na kufanya kazi kwa pamoja. Tena, when are we signing the agreement? Now. Haya, mimi nataka kuona hiyo agreement kwa sababu nangojea fertilizer. Mimi ni mkulima. Nataka hawa wakulima wengi wanangojea hii fertilizer kutoka geothermal itafika 24 months tutangojea, na tunahesabu kutoka leo. Very good. Asanteni sana na Mungu awabariki. Thank you very much.
So at this point, allow me to invite Dr.
their underlying purpose and objectives, rather than adhering to a rigid or literal reading. Further, courts have emphasized the need for a flexible and forward-looking interpretation of the Constitution to meet the needs of a modern state. With the above interpretive principles in mind, we will now deal with other issues posed in the application under consideration.
I will deal with the second issue on whether the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. There is no doubt that this was the most contested issue in the subject application. Article 165, Sub-Article Sub-Article 3 and Sub-Article 4 of the Constitution provide for empanelment of benches of an even number of judges as follows. Permit me not to go through that. In dealing with the above issue, courts have taken two diametrically opposite positions. One of them being that the assignment of judges is a constitutional duty which can only be undertaken by the Honorable Chief Justice. As such, the Honorable DCJ cannot assign judges under Article 165, Sub-Article 4 of the Constitution. The other position posits that although the duty to assign judges is provided for in the Constitution, its implementation is administrative, and that duty can be undertaken by the Honorable DCJ. In Kenya Medical Research Institute versus AG, which was a three-judge bench of this court, held as follows. They quote, paragraph 37. Therefore, by empaneling this bench, the Chief Justice was carrying out his constitutional mandate as opposed to similar functions under the former Constitution, which were hinged on the constitutional provisions and were merely administrative. End of quote. In Leina, Conchela, and others, which was a five-judge bench of this court, the court went ahead and described the role of the Chief Justice under Article 165.4 as constitutional as opposed to a merely administrative function. It also said, it is our view that a constitutional mandate of the CJ can be judicial, administrative, or political, and the current Constitution does not indeed state that the Chief Justice is the head of the judiciary which embodies all these functions. The learned judges in that empaneled bench then found that the constitutional mandate exercised by the CJ under 165.4 of the Constitution is an administrative function. The court also elaborately dealt with the issue as to whether such an administrative function could be undertaken by the Honorable DCJ, and in the end, the court rendered itself as follows. I quote paragraph 78. It therefore our finding that constitutional function of the CJ to assign benches under Article 165.4 being an administrative function can be performed by the Deputy Chief Justice when the Chief Justice is for good reason unable to perform. End of quote. The petitioners in these matters also cited the decision in Okoiti versus JSC and another, which is constitutional petition number A408 of 2020, as buttressing the position that the assignment of judges is a constitutional mandate and the sole preserve of the Honorable the Chief Justice. The decision was delivered by yours truly, who is part of this expanded bench. We have carefully considered the said decision. One of the issues therein, which may be said to have a bearing on this matter, was whether the Honorable CJ could rely on Section 5, subsection 4 and subsection 5 of the Judicial Service Act to authorize the Honorable DCJ to serve as the acting Chief Justice when the Chief Justice was proceeding on leave pending retirement until when a succeeding Chief Justice was appointed. As the matter did not deal with the nitty-gritties of the aspect of assigning of judges, but rather the constitutionality of the actions of the CJ who was exiting service, we respectively find that the issue is not at par with what is under consideration in this instant application. The said decision is hence distinguishable. Returning to the matter at hand, it is imperative to look at the various terms which come to play in this matter, including the administrative actions as well as judicial actions. We have gone through that. I do not think there is need for me to read all that. It's in the ruling, and I proceed to state that from the above discourse, we do not find any difficulty in affirming the position that a constitutional mandate of the Honorable Chief Justice can be judicial, administrative, or political. We further find and hold that the constitutional mandate exercised by the Honorable Chief Justice under Article 165, Sub-Article 4 of the Constitution is a constitutionally administrative function. We shall now consider whether the function of the Honorable Chief Justice under 165, Sub-Article 4 of the Constitution can be performed by the Honorable DCJ. Article 161 of the Constitution establishes the office of the Chief Justice as the head of the judiciary, and that of the Deputy Chief Justice as the deputy head of the judiciary. Article 163 of the Constitution creates the Supreme Court and designates the Honorable Chief Justice as the president of the court. The Deputy Chief Justice is to deputize the Chief Justice and is also the vice president of the court. Article 171 of the Constitution establishes the Judicial Service Commission, or the JSC, as one of the Chapter 15 commissions. The Honorable Chief Justice in JSC is the chairperson, and in this scenario, and unlike the constitutional architecture in Articles 161 and 163, the Honorable DCJ is not the vice chairperson of JSC. Running alongside the foregoing are the functions of the Chief Justice and the Honorable DCJ as provided for in Section 5 of the Judicial Service Act. The provincial states as follows. This is in respect to administration of the judiciary. I do not need to read through all that. I proceed to say that the decision in Lena Conchela also dealt with the definitions and various types of deputies, and ultimately rendered itself in the following manner. I think this one I should quote. Paragraph 77, it says, it has been canvassed before us that where the Constitution intends the Deputy Chief Justice to act on behalf of the Chief Justice, it has expressly stated so. Specific examples cited were Articles 141.1, 144.4, 148.4. These provisions fall under Chapter 9 of the Constitution that deals with the executive. This chapter does not have a general provision as regards the deputization of the Chief Justice by the Deputy Chief Justice, as is provided for in Article 161 2b in Chapter 10 of the Constitution on the judiciary. Hence, the provision of the deputization of the Chief Justice in Chapter number 9. A holistic and purposeful interpretation of Article 161 2b of the Constitution and Section 5 of the Judicial Service Act leads us to the conclusion that the Deputy Chief Justice substitutes the Chief Justice where necessary. End of quote. In the end, the learned judges found and held that the constitutional function of the Honorable Chief Justice to assign the benches under Article 165 for the Constitution, being an administrative function, can be performed by the DCJ when the DCJ is for good reason unable to perform this function. On our part, we have carefully addressed our minds to the issue. We find that there was a deliberate scheme by the drafters of the Constitution for the Honorable DCJ to deputize the Honorable CJ as Deputy Head of the Judiciary and as the Vice President of the Supreme Court, but not in the JSC. Such was an emphasis on the various manifestations of the constitutional duties bestowed upon the Honorable Chief Justice and the Honorable DCJ. As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provisions of Article 259, Sub-Article 3b of the Constitution, which states as follows. This refers to construing the Constitution, and Article 3 provides as follows: every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, B, any reference in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the functions of the office at any particular time. The above provision creates three tiers in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular time. In our understanding, and against the background of the doctrine as stated, the drafters of our Constitution were deliberate about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for offices and their functions to be performed even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that could disrupt the functioning of state officers of public institutions, thereby promoting administrative efficiency and upholding the principles of constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that state and public officers continue to function effectively, even during periods of transition or when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without disruption. For this reason, the functions of Article 165, Sub-Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging its functions in an interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled this very bench on the 14th day of October 2024 to deal with 6 constitutional petitions that inter alia challenged the first petitioner's impeachment process in the National Assembly. The said petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions challenging the impeachment of the first petitioner in the Senate. To us, it is beyond peradventure that the Honorable DCJ can assign judges under Article 165, Sub-Article 4 of the Constitution, whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we do not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised any red flag. Thank you.
Right. I will deal with a question of other related issues that came up during the view of the benches and panelment by the Deputy CJ. Several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issues raised. During the submissions, an issue was raised concerning the directions issued by the 3-judge bench and the transmission of the files in Nairobi Petition E565 of 2024, Kerugoya Petitions E013 and E014 consolidated, as well as E015 of 2024. A review of the CTS, that is a case tracking system, confirms that the petition in E565 of 2024 was filed on the 18th of October 2024 at 8:00 a.m. Later that same day, approximately 5 hours on, at 1:51 p.m., Justice Chacha Muita dealt with an application filed under certificate of urgency which had been submitted alongside the petition. By 5:33 p.m., roughly 3 hours after the earlier application, a notice of motion application dated the 1st of October 2024, it was dated the 1st of October 2024, was filed, this time by the respondents seeking the following orders. One, that the application be certified as urgent and service of the application be dispensed with in the first instance. Two, that pending the hearing and determination of that application, inter partes, this honorable court be pleased to set aside, vary, or review the orders issued on the 18th day of October 2024, that is the interim conservatory orders. Three, that in the alternative, this court be pleased to set aside, vary, or discharge the ex parte orders issued on the 18th day of October 2024, and four, that this honorable court do issue any other orders it deems fit in the interest of justice. Following its empanelment on the 18th of October 2024, and having received directions from the Office of the Deputy CJ, the bench deliberated on the appropriate directions to be issued. On the 19th of October 2024, at 12:20 p.m., the bench issued the following directions. That in light of the urgency of the matter and the weighty issues raised therein, we direct that the application be served and responded to forthwith for hearing inter partes on Tuesday, the 22nd of October 2024 at 11 a.m. in open court number 18. Petition E013, on the other hand, was filed on the 25th of September 2024 at 8:33 p.m., while petition E014 was filed on the 2nd of October 2024 at 7:07 p.m., both way past official working hours of the court. The CTS will further show that an application in E014 was filed on the 30th of September 2024, and directions were issued on the very same day, although the matter was not certified as urgent. Subsequent directions and a ruling issued on the 11th of October 2024 resulted in the consolidation of petitions E013 and E014, followed by an order for empanelment. As the record on CTS will further show, the directions issued by the court in E014 of 2024, which were issued on the 2nd of October 2024, were again issued at 6:22 p.m., which is outside of what one would call the routine working hours of the court. This was due to the urgency demonstrated in the application, which sought directions regarding the then ongoing public participation process. The bench takes great exception to the petitioner applicant's conduct that when favorable to them, issues of orders, rather orders issued outside of what one would refer to as the normal working hours of the court raise no concern. However, when the court acts in an instance where it has been moved by any other party and likewise proceeds to deal with an application at hand, the applicants show their indignation. Moving to petition E015, the CTS again would show that the same was filed on the 18th of October 2024, and once again following the directions issued by the court, this bench was empaneled on the 18th of October 2024 to hear all the three petitions, that is E565 of 2024, E013, E014, and E015, all of 2024. From this sequence of events, it is notable that the interaction between council and the courts on an almost real-time basis is not novel, and is in fact a practice that councils are well familiar with. The CTS enables both council and the court to operate in real time, transcending traditional time limitations. This fact also buttresses the argument that with the advent of the CTS system, it is not unusual for courts to issue directions within the filing of an application or outside of what once again would be referred to outside the routine work hours of the court where circumstances do so require. Moreover, in raising the issue of improper seating, the applicants omitted a crucial fact, which was that the court had been moved by the respondents in petitions E565 of 2024 and E015 of 2024. As such, the court did not convene suo motu, but rather in response to the applications before it. The applicants have repeatedly referred to this convening as a sitting of the court, a term that we feel as a bench requires clarification and demystification. It is a matter of judicial notice that since the onset of the COVID-19 pandemic and the introduction of the case tracking system, the tradition of dealing with certificates of urgency has since evolved. Allow me to quote the practice direction number 19A of the High Court Practice Directions of the 11th of January 2022, which states as follows: that applications filed under certificate of urgency shall be considered by the judge, we emphasize here, at the earliest opportunity. While the practice directions also stipulated that applications filed after 12 p.m. may be considered the next working day, the full adoption of the e-filing system across the judiciary has largely rendered this provision obsolete. Applications are now processed almost in real time, a fact well known to the justice users across the country and which we have demonstrated in this ruling. Furthermore, practice direction 19B confers discretion upon the court to issue orders or directions without the attendance of advocates or parties. This implies that the court can indeed issue directions on an application without the need for a formal sitting. The relevant provision once again reads as follows: that the court may, in its discretion, issue orders stroke directions without the attendance of the advocates or parties. I end quote. In this case, the issue has been raised that this court allegedly sought and considered an application by the respondent on a Saturday outside of the official court hours. The ordinary definition of a sitting, as provided in the Black's Law Dictionary, is a formal occasion when the court convenes to conduct its business. In this instance, no such formal sitting occurred. In this instance, may I repeat, no such formal sitting occurred. Rather, the bench merely conferred and issued directions electronically as expressly permitted under Practice Directions 19B. This is markedly different from a court session in which the bench is convened to hear and determine a matter. Furthermore, no evidence or proceedings have been presented before this bench to support the claim that a formal sitting did take place. Accordingly, it is only fair and reasonable for the parties to dispel any notion that this bench convened to hear arguments from any party ex parte